Um, and unfortunately, this traditional view of the asylum seeker as male, together with narrow and fairly rigid interpretations um, of what constitutes persecution, has had the effect of denying women their right to international protection. Women who fear persecution as a result of transgressing religious, customary, or social norms that the practices themselves may be based on an assumption of the inferior status of women, which can be manifested in discrimination, sever enough to qualify as persecution, for example, female genital mutilation, honor killings, or dowry burnings, or transgressions may be met with punishment so disproportionately severe as to amount to persecution. For example, in countries such as Iran, where women can be flogged for wearing lipstick, or Afghanistan, where they can be stoned or even killed for going out unaccompanied by a male relative. Such persecution has regularly been sidelined by the argument that there is no state culpability which is required in appeals for international refugee protection in cases of private abuse. States not only have a negative obligation not to violate a citizen's rights, but a positive obligation to respect and protect such rights. In 1988, the Inter-American Court in the case of Velázquez Rodriguez ruled that an illegal act which violates human rights and which is initially not directly imputable to a state can lead to international responsibility of the state, not because of the act itself, but because of the lack of due diligence to prevent the violation or to respond to it as required by the convention. In addition, the states demonstrate inconsistent responses to accept honor killing as a ground for asylum, having a very restricted interpretation on particular social group and convention grounds. However, there is nothing in the convention definition that allows for the exclusion of a claim on the basis that it is a persecution shared with large numbers of others. As stated by the former Canadian Refugee Status Advisory Committee, person is a refugee when he or she is persecuted once or persecuted with others. A woman cannot and should not be disqualified from claiming refugee status simply because large numbers of women experience persecution in their lives. If it is assumed that gender in principle is a sufficient identifying factor held in common so that all women may comprise a social group, is this enough for convention purposes to show that the woman who faces domestic or even public violence is persecuted for reasons of membership in that group? Gender-related persecution is sometimes more subtle than other forms. It can take the form of restrictions on the way a woman behaves, or it can involve in forcing her to act in a certain way. There has been increasing concern among advocates and practitioners about the way in which the asylum claims of women who experience gendered social norms and mores are interpreted with international refugee law. In many contexts, women are subjected to discriminatory treatment and social mores which are enforced through law or through the imposition of cultural or religious norms which restrict their opportunities and rights. Gendered social mores and discrimination are seen in but are not limited to legislative discrimination. For example, Pakistan's hudud laws are restrictions on women's movements, indoor activities in Afghanistan, dress codes, employment or education restrictions, behavioral restrictions, for example, not going out in public without a male protector, marriage-related harm, including the consequences of remaining single, separating, divorce, and widowhood, The politics of gender and sexuality is reflected in the concept of honor, which has become strongly associated with women's sexual behavior in many contexts. Within this concept, any actual or perceived violation of what are deemed to be appropriate gender relations are viewed as defiling the honor of the woman and in turn the honor of the nation itself. Protecting the honor of the woman and in turn the honor of the nation therefore gains political significance and will be enforced either directly through the state as in the legislated discrimination and laws regulating women's behavior or through a woman's family and community. In asylum applications, critical to the formulation of these claims is the fact that the applicant must establish that the government is the source of the persecutory measure or that the government is unwilling or unable to protect her from persecution. When the treatment is through discriminatory statutes or laws which may be gender neutral but are applied in a manner which target women and which are enforced by the government, state involvement is clear. The issue of the failure of the state protection is often one which is critical in asylum cases involving social mores and discrimination because it is often members of the family and community who ensure that the state's approach is enforced. Although a woman who is perceived to have brought shame upon her family, community and nation may have very real fears that she will be punished by the state if forced to return, and more commonly she will fear persecution from her family and or community. The male members of the family believe that they can only regain their honor and that of the family and or community by murdering the woman for her alleged sexual transgressions. The principle that states are responsible for changing domestic laws in order to bring them into conformity with the international human rights law could simply be based on the notion that the state is bound to do so under the international custom or treaties. The argument that this obligation can be founded on customary international law may be controversial and strained in the relation within the human rights of women. Moreover, it could be difficult to establish a principle of customary international law prohibiting all forms of discrimination on grounds of gender. The rationale of binding agreements would of course apply when the state is party to the relevant treaty. For example, Articles 12 and 5A of the International Convention for the Elimination of All Forms of Discrimination Against Women requires state parties to implement the appropriate measures to eliminate discrimination against women in customary practices. And even though it can be argued that there exists a positive obligation to protect the right to life also under customary international law, the enforcement mechanisms in relation to customary law are still weak.